Good morning. Good morning, everyone. My name is Gita Sancano, and I am the Associate Symposium Editor for the Journal of Business and Technology Law. Today's second panel will be discussing IP issues inherent in VR and AR technology. It is my distinct pleasure to introduce the second moderator for today, Professor Patricia Campbell. Professor Campbell is the director of our Intellectual Property Law program and is the director of the Maryland IP Law Research Center at Carey Law. In addition to her law faculty appointment, she is a faculty advisor for the Journal of Business and Technology Law. She also holds an appointment as an associate professor at the Maryland Technology Enterprise Institute, located at the A. James Clark School of Engineering in College Park. Ladies and gentlemen, please help me in introducing and welcoming Professor Campbell.
Thanks very much and good morning. Our next panel is going to talk about all sorts of different intellectual property implications arising out of virtual reality, and we're going to look at copyright, trademark, and patent issues. So I'd like to introduce our first speaker, who's already known to some of you. Professor Nathan Robertson is our Director of Information Policy and Management here at Maryland Carey Law. He's our copyright professor. Some of you may have taken his class this past semester. And he's also a graduate of Maryland Carey Law. I understand that he graduated magna cum laude, so I'm impressed by that. Also, I have no firsthand knowledge of this, but I understand that Professor Robertson is an avid gamer, so you'll have to ask him about that at some point. Nathan?
Ready Player One. So how many of you have read the book? Seen the movie? Not many of you. That's really surprising. So it was really timely, I think, that JBTL decided to have this symposium on virtual reality right as this new Steven Spielberg movie about virtual reality was about to come out. And it's based on a science fiction novel by Ernest Cline. And it's a movie that's set in the future in which the real world has basically gone to hell, and basically all important aspects of everyday life take place in a virtual reality simulation called the Oasis. Those aspects of everyday life that are included there include like all education. People go to school in virtual reality. Most business takes place in virtual reality. Dr. Caritas this morning talked about online meetings. All meetings are online meetings in the story of Ready Player One. And of course, just about all entertainment is virtual reality entertainment too. So the plot of the movie and the book is they differ a lot in terms of what actually happens, but the basic plot is that the creator of Oasis has left his unbelievable fortune to the first person to discover and master these Easter eggs that he's hidden in the virtual reality. And the Oasis world contains like every arcade and classic computer game that ever existed, and all these books and movies and TV shows, even Dungeons and Dragons adventures and stuff from the late 20th century, from like Family Ties to War Games to Monty Python to Voltron. Inside that virtual reality world, inside the Oasis, and as part of the Easter egg challenges, you can not only read and watch all of that material, but you can play through interactive adaptations of them. So you can pilot classic fictional starships like the Serenity from Firefly or TIE fighters from Star Wars, or you can go on D&D adventures, or you can operate a mech robot like Mechagodzilla or Ultraman, and you could live the life of a movie character like maybe Marty McFly from Back to the Future. Ready Player One is set in the year 2045. So at this point, all of that old stuff, all that 70s and 80s and 90s geek culture is like ancient history. It's 60 or 70 years old, right? It's a couple of generations removed from the life of the young Easter egg hunters who are hunting for this fortune. But if current copyright law was still in force in 2045, all of that cultural material from the 70s and 80s would still be under copyright. So what is a copy of a novel or a book or a TV show inside a virtual reality universe? Well, it's a copy, and it's implicated by copyright law. Distributing that copy in virtual reality, it implicates the distribution right that's part of copyright law. The adaptations that virtual reality participants can play through, those are derivative works implicated by the derivative work right of copyright law. So we assume that within the OASIS right, that this fabulously wealthy developer of the OASIS can negotiate licenses with the license holders for the rights to the material that it chooses to incorporate. Rights transactions between corporations for things like that are very common already in the real world, right? So the novel was originally a novel by Ernest Cline. He sold the rights to make the movie, which is a derivative work, to Steven Spielberg's production company. Electronic Arts currently has the rights to make video games out of Star Wars. Funcom has the rights to make video games from Conan the Barbarian. So these sort of rights transactions for copyright between corporations are standard, and they're commonplace. Virtual reality technology is not going to change these relationships. The VR corporations are still going to license rights. But what's a lot more interesting to me is what's going to happen for user-created material inside virtual reality universes. So what we have here is a poster for Ready Player One, created by a fan. So this is fan art that you can find on Tumblr. Some fan was particularly enthusiastic about Ready Player One as a book. This is the book version that he was writing, that he developed the poster for, and decided that he was going to create art. Posted it online. So what does that mean? What are the implications of fan art, fan fiction, and fan-created, user-generated content in virtual reality? So let's first talk a little bit about the traditional outlines of copyright law. So you have a creator who comes up with an idea, they write a story about it. Upon fixation, as soon as that story is created, it receives copyright protections. Those copyright protections are the exclusive rights to do any of the following: to make or distribute copies, to perform or display the work publicly, or to create derivative works. So these protections automatically adhere upon creation and fixation. So what that author then will do is license that distribution right to a publisher. The publisher creates a bunch of copies of it and sells those copies to the public. And so that's the traditional way in which creations get disseminated to others, and that copyright is protected and maintained through that process. Similarly, you may have someone who has the idea for the movie version about the story of the boy wizard in the wizard school, right? And so what the original author will do is provide a license to create the derivative work. The movie production company creates the movie, it receives copyright upon fixation, and then in order to distribute that to the public, it's disseminated to movie theaters, and the audiences go to the movie theater to watch the movie. What you get from this sort of traditional copyright regime is that you get a very significant distinction between the people who are creators. And they're these great creative giants, right? And they get copyright protections in their creations as an incentive to create. And then you also have the consumers who fork over the cash as the incentive for the creators to create. And there's this very clear distinction between who gets those copyright protections and who pays for those copyright protections. So is that really what's happening when consumers are consuming creative content? No. When you're a little kid, you say, we're going to play Lone Ranger, and I get to be the Lone Ranger. Or we're going to play, and I get to be Princess Ariel, and I get to be Princess Elsa, right? So people receive creative content, and it inspires them to be creative. And so consumers are not just consumers. Consumers are new creators. And they are full of these ideas about ways that they would continue the stories that have inspired them. So what then happens if someone wants to share, one of those people who is just a consumer now, wants to share their idea? Can I share my new adventure for the characters? In the traditional environment, the answer is no, right? You take that to a publisher. The publisher says, well, no, first of all, it's very expensive, and secondly, it would be a violation of copyright, and the publisher is an agent of the copyright owner and has some incentives to maintain that regime. And so there were these built-in impediments that sort of prevented the kind of sharing of user-generated content back in the old MeatSpace days when it was difficult and expensive to distribute. But now, in the world of the internet, can I share my new adventures for the characters? What's stopping you? It's so easy to create and distribute, so easy to distribute. It's still a violation of copyright law, but there aren't those same built-in physical world MeatSpace impediments to the distribution of content. So this is the world where we're in right now, which is that despite copyright law, all of these users are able to share their creative content that's inspired by the works of the great creators with one another, right? So they get to share their new adventures, they get to share their video games, they get to share their pictures and stories. So there are platforms that exist for this right now. Fanfiction.net is a very popular platform that hosts thousands and thousands and thousands of fan-created stories that are inspired by the worlds that are copyright by original creators. And there are certainly copyright tools that the original creators can use to end those if they don't like them. There are DMCA takedown notices that they can issue, and fanfiction.net is very responsive to creators saying that they don't want derivative works posted there. But that's not the only platform. There's so many platforms that it's almost impossible to police the ability to share. That's the world that we're living in right now before we even hit virtual reality. So when you add something like an entire virtual reality world, so the creator or the creating company of the virtual reality world is going to have copyright in that world too, as an expressive creation, as well as in the copyright of the computer code that generates it and all of that. But inside many virtual reality environments, what you're going to have is all of the tools that the internet currently allows for distributing, plus all of these tools for creation. So you can imagine a virtual reality world working a lot like Minecraft, where you can build just about anything. It's a sandbox for you to create. And if you are the same kind of person who is really interested in Star Wars and wants to write Star Wars fan fiction, maybe the next thing that you want to do is build yourself a little virtual reality Millennium Falcon. I'm on that's what I want to do, right? The first thing I want to do is I want to build myself a Millennium Falcon, and then I want to pilot it, right? It's so exciting. And all of these things are going to exist in the virtual reality environment and continue to implicate copyright in ways that will be difficult for copyright owners to control. There are some, so who is just a consumer now when people who were traditionally just consumers can really be creators? There are some potential solutions to this copyright quandary, but the solutions that you choose are going to depend on whether you really want to maintain this hierarchy and boundary between creators and consumers, or whether you want to blur those lines and let consumers really become creators and share in what gets created. So if you want to maintain the lines, it's really easy. You just enforce copyright law as it is, with copyright enforcement and DMCA takedowns. There's some problems here because the people who are doing all of that creation are your biggest fans. And it's probably not the best public relations action to sue your huge fans, right? You really want them to love you, but you want them to love you and continue to give you money. So that sort of aggressive, litigious response is maybe not the best. So what we actually often see is acquiescence. Creators say, you know, as long as it's not commercial, as long as you're not writing X-rated stuff, go ahead, right? There are also other models that have been proposed. We could have voluntary licensing. So a creator could actually say, listen, for non-attribution, non-commercial use, go ahead, write your stories. I'm going to issue my stuff under an explicit Creative Commons license. Has anybody heard of Kindle Worlds? I hadn't either before I started reading about some of this. Kindle Worlds is actually a model through Amazon with Kindle, which actually is a fan fiction platform. So authors authorize their worlds for Kindle World use. Authors can then write fan fiction, get it sold, get royalties of like 20 to 35% on the $4 that they get for every sale, and they actually get to participate. It's not a very popular platform. One of the reasons why is because Kindle Worlds requires that you be at least 18, and fanfiction.net surveys have suggested that like 80% of the participants in fanfiction.net are, you know, teenagers, pre-18. And so there are some impediments to the specific Kindle Worlds model, but it could be conceptually a really interesting model for creating opportunities for consumers to become rewarded creators. Another thing that's been proposed is compulsory licensing. Compulsory licensing already exists in the world of cover music. And so it's initially sort of thinking, you know, what you would be, you require me to license my material for derivative works? Well, we do that sort of already for music. We could do that for everything else. I'm interested in writing fan fiction, I mail in my $10 and then I get to write my short story. So these are options that are available for the fan fiction universe. There's also this big elephant in the room, though, for virtual reality, which is the end user license agreement. Throw out copyright law entirely and make a binding contract of adhesion with your users. These vary a lot. In the existing video game world, sometimes the end user license agreement says all of the material that you might produce in here becomes our property. Whoa, that's harsh. Some of it says the intellectual property that you produce inside this is yours and is your property to continue to exploit. So there are lots of different options that could happen inside of a virtual reality universe with an end user license agreement replacing the basic law of copyright. And that is certainly all that I have time for. This is the t-shirt that I was going to wear today, but relying on meat space delivery, it got delayed and I didn't get to wear it today. So I'm not able to wear for you. My graphics are amazing, but the storyline and the gameplay were terrible. Thank you very much.
Thank you. Our next speaker is going to talk about trademark issues, and again, she's known to many of you. Julie Hopkins is counsel at Womble Dickinson here in Baltimore. She's also an adjunct professor here at Maryland, and she teaches our class on trademarks and unfair competition law. And like a few of our other panelists, Julie is a graduate of Maryland Carey Law. Julie?
Give me a second here. All right. That was great, Nathan. Thank you. So I'm going to be talking about trademarks and virtual and augmented reality. And I thought I would start by doing a quick trademark primer so that everyone's kind of on the same page when I make reference to dilution and trademarks and what that really means. So what is a trademark? A trademark can be a word or a symbol that's used in connection with a good or a service in commerce to identify the source of a good or service. So trademarks are brands. They represent the goodwill, the reputation, the quality that is built into that brand, that when we hear a brand name like, for example, Rolex, we know we're getting like a luxury watch, right? You have an image in your head of what Rolex is. When you hear Starbucks, whether you like Starbucks or not, when you go to a Starbucks, you know exactly what you're getting. The coffee tastes the same at like every Starbucks, right? So that's the reputation, that goodwill that goes into a brand. And trademarks protect that goodwill. So trademarks can be words like Nike. Nike is a trademarked word. Can also be a design or a logo. So the Nike swoosh is a protected trademark. Yahoo here in that special font is a protected design mark. Can also be taglines like "Just Do It." Product design like the Coke bottle is protected as a trademark. Product packaging. We talk about trade dress. If you think about McDonald's, the look and feel of a restaurant, of a store, could be protected as trade dress. It's that when you walk into a McDonald's, you don't need to see the sign that says McDonald's to know that you're at a McDonald's. You know, because they all look the same, they use the same color scheme. All of those details go into providing a protectable right and trademark that we call trade dress. Color is also protected as a trademark. The pink insulation, the fact that the insulation is pink, the color pink is protected as a trademark. And sounds and smells can also be protected. So you hear the Intel chime, that is protected as a trademark. I did have a link, I couldn't get it to work for some reason today, but sounds are protectable. Anything that can identify the source of a good or service is protectable as a trademark. So what is trademark infringement? The statute for what is trademark infringement is up on the screen, but we're really talking about when someone is using a mark that is confusingly similar to another's trademark, that's likely to cause confusion for the consumer. So when the consumer sees that mark, they don't know who the source is, and they might get the source wrong as to where the good or service is coming from. And the key here, one, again, is use in commerce, and this is going to come up repeatedly in my talk. It has to be a use, so providing a good or a service in commerce to a consumer. But it also has to cause confusion, or be a likelihood that there's going to be confusion among consumers. And so there's a bunch of factors that go into that, like the similarity of the marks, what they look like, the similarity of the goods and services that are being offered, among some other factors. Then there's trademark dilution. Trademark dilution is another potential claim for a mark owner that's famous. So if a mark rises to the level of being incredibly well known, Nike is probably a really good example of a famous trademark. So not all trademarks rise to that level, but if you are a famous mark, you have an extra claim potentially for trademark dilution. And trademark dilution is really when a brand is being, what it sounds like, being diluted by other uses by other parties. So that could be by blurring or by tarnishment. And by blurring is where, for example, people are using trademarks for Nike, but not for shoes or clothes. They're using it for office supplies, offshore drilling services, you name it, that starts to dilute the Nike brand. You no longer are going to immediately think Nike and shoes, you're gonna start thinking it could be a whole host of other things. And then dilution by tarnishment is when the mark is being used in a way that is hurting the brand in some way. So an example would be Nike for a pornography website, right? Nike doesn't want their brand being used in connection with something that could hurt it in some way. And so that's dilution by tarnishment. So keep this in mind because, again, dilution is going to come up when we look at how trademarks are being used in the virtual world. There are defenses to dilution, and these are important. Comparative advertising is one. We allow comparative advertising in the United States. Parody And criticism and political commentary, these are all defenses to dilution that are available if you're going to use someone else's trademark. And then we have what is kind of a little bit tangential to trademark is celebrity rights. So rights of publicity, false endorsement, false association. So part of this falls under the Lanham Act, which is unfair competition, and that's the false endorsement, false association. So a company, as well as an individual like a celebrity, would be concerned about their likeness or their mark being used, and someone thinking that they're endorsing another's product or another's mark because their trademark is being used, or their likeness, or some other element of the celebrity is being used. And so a celebrity or a company can go under the Lanham Act under unfair competition as a potential claim. Celebrities also have, in some states, but not as a federal right, rights of publicity. It's not available in every state, but in a lot of states, it's another cause of action that allows a celebrity to prevent someone else from using their likeness for commercial benefits. So again, we've got this language of being in commerce. They want to control their image and when their image can be used. All right, so let's take that background information and put it into the virtual world. So first, I'm going to talk about trademark rights in real world trademark rights being used in virtual reality. So that's like Nike having a federally registered trademark in the United States in the real world, and their trademark then being used in the virtual world. And how does that happen, and how can they stop that, and what do you do? So first, let's look at this from the user perspective, and I think Nathan did a really great job of talking about the user, and the user being in the virtual world. So the user creates an avatar. The avatar is wearing a shirt that has the Nike swoosh on it. Is the user infringing Nike's trademark rights by wearing a Nike branded t-shirt? Probably not, because they're not in commerce. They're not selling that t-shirt, they're just wearing it. So that's probably not going to rise to the level of being a trademark infringement. But if they create a store in the virtual world and they start selling Nike branded t-shirts and shoes, then they are in commerce, because they're in commerce in the virtual world. And that will likely rise to the level of being a trademark infringement that Nike can go after. So you have to look at what the user in the virtual world is actually doing to see whether it rises to the level of being an infringement. And this is possible because there's virtual currency. So because there's virtual currency, and that is equated to real dollars or whatever the currency is, you're in commerce. And so again, that's really the question when you're looking at this. Does it rise to the level of being in commerce? So there's also rights of publicity here. So what if the user creates an avatar that looks like Kim Kardashian? Has that risen to the level of being a commercial activity that would fall under a right of publicity claim or an unfair competition claim? Potentially no. But if the Kim Kardashian avatar is now acting in a commercial way, trying to sell something with their likeness, then we're potentially rising to the level of having a right of publicity or an unfair competition claim in the virtual world. So users, if you're a user in the virtual world, you really should consider whether you need a license from a trademark owner to be entering into these commercial activities within the virtual world. So then what about the platform or the game developer or the virtual world developer? What about them? Are they liable if a user sells a Nike t-shirt? It's possible that they could be liable under secondary liability concerns because they're providing this commercial space for them to do so. But a lot of times, the platform or the generator of the virtual world will have terms of use policies and things that alleviate their liability in this situation. So you'll often see that. But creators of virtual reality are creating these worlds, and Nathan touched on it, where they're bringing in trademarks, copyrighted works, but as well trademarks, trade dress into the virtual reality world that are potentially infringing on someone's trademark rights. And so they are also going to have to get licenses and get approval in order to be doing that. So from the creator's perspective, there's also a need for a license to not infringe on the trademark owner's rights. So what can brands do from this perspective? They need to police their marks. They need to not just look at the real world, but they have to look at the virtual world and see what's being done. So they can offer licenses, enter into license agreements with both the platform as well as with the user. And they can open up their own stores. So there's this whole opportunity for brands to enter the virtual world and set up shop, just like they do in the real world or on the internet. And so there's a host of opportunities for them to interact with their potential customers, really build their brand loyalty by participating themselves and being in the virtual world as well. And then lastly, they can work with the platform to essentially have takedown policies. So if someone is violating the terms of use of the virtual reality world, they are using people's trademarks in commerce, and that's violating terms of use, then the platform has the ability to stop them from doing so. And so the trademark owners can partner with the platforms to enable that to happen. So what about user-generated trademarks in the virtual world that you then want to somehow enforce in the virtual world or in the real world? Who owns IP, specifically trademarks, that are created by a user in the virtual world? So instead of they're creating a T-shirt with Nike, they've created a T-shirt with their own logo on it, that they've somehow created a business within the virtual world, and they want to protect that right. Or in this case, which I'm going to talk about in a minute, you create your own avatar, and that avatar becomes particularly famous and well-known in the virtual world. How do you go about preventing other people from copying you and causing confusion with your own brand? So the user generally owns the trademark rights that are created in the virtual world. Sometimes the platform owns it. It's really going to come down to what the terms of use say, but it's likely the user is going to be owning the work that they create and that they upload. But if they want to have an enforceable trademark in the virtual world or in the real world, again, it has to be used in commerce. So just by creating an avatar or creating a logo and you're not selling anything doesn't mean you have an enforceable trademark right. So what does a user do in that situation? So here, this is an example of an avatar that was created. This was from Second Life, which was really big in the early 2000s. A woman by the name of Alyssa LaRoche created an avatar, a name called Amy Weber in Second Life, and this is her avatar that you can see up on the screen. And she decided to get it trademarked. I mean, she was like an incredibly well-known avatar within Second Life. And she tried to get it trademarked, and she succeeded. And she did so by registering it as a service rather than a good, because she wasn't actually selling a good in connection with this avatar. So the goods and services she registered for were computer programming services, namely content creation of virtual worlds and three-dimensional worlds. So that's the service, which is really interesting, because how is she doing that? What service is she actually providing? And so you have to submit a specimen showing use with the trademark office to get a registration. And so this is the specimen that she submitted, and it's a screen capture from the virtual world with basically a billboard where she was advertising that she provides virtual services in the virtual world, and this registered, okay? It has since abandoned. You have to renew a trademark. You have to show that you're continuing to use it in commerce after between the fifth and sixth year from registration, and she did not submit evidence of continuing to use it, so it went abandoned, but she did successfully get this registered. So this is proof that there is an ability to take user-generated trademarks and protect them in the real world. Now, whether someone was selling T-shirts with this avatar on it and she could stop them, I'm not entirely sure she could, but she could probably stop them from creating similar avatars within the virtual world using this. All right. So now I'm going to switch to augmented reality. Augmented reality has a whole other host of related issues. This is a screen capture from a YouTube video that basically shows an extreme depiction of sponsored content. So I'm going to pronounce his name wrong. Kiichi Matsuda created this video called Augmented Hyperreality Domestic RoboCop. And in it, this is his kitchen. And augmented reality put branded ads all over everything in his kitchen. And as you can see, the ads are everywhere for everything. And so what in the world are trademark brand owners going to do with this type of situation? Obviously, this is extreme. When you're in augmented reality, maybe you're on your cell phone, you're holding your cell phone up to a product, and then you see some augmented information that comes to you through that. But this is where we could end up going. I mean, crazy. So trademarks that are displayed in this manner could be infringed or diluted just as they are in the online world, and just in the real world, how we use how trademarks are copied, causing confusion, et cetera. So trademark owners can create their own augmented reality with their own brands, and trademark owners are doing this. So hundreds of companies, from Starbucks to Lego, have already done successful marketing campaigns where they have a mobile app, and they are able to, a user can find augmented content about the brand by using the app on the cell phone to learn more about the product. That's great. They get to control the messaging. That's fantastic for the brand. They like that. But what happens when you take your app and you put it over a McDonald's logo, you get your golden arches, and an ad for Burger King pops up? Right? What they don't want, McDonald's does not want that, right? But can Burger King do that? The question becomes, is that comparative advertising? Is it similar to Google AdWords, where behind the scenes, some algorithm is taking place that's allowing this other brand to pop up? With AdWords, you type in McDonald's, and you get your search results give you Burger King, right? Courts have said, generally, that's okay. That's used in commerce, it's comparative advertising, and in certain cases, that's okay. So can Burger King augment reality, put its logo on top of McDonald's? We don't know, possibly, but of course, brands are going to be really concerned about this and are going to want to police it.
Julie,
Yes.
these are really interesting questions, but can we wrap up?
Am I going over?
Well, a bit.
All right. So I will go very quickly. There's the social commentary issue. This is an actual app. BP created a consumer group created an app that when you put it up against BP, it simulates an oil spill. Obviously concerns, but probably likely able to be done. Pokemon Go, all sorts of trademark issues within Pokemon Go. We have trade dress protected buildings. Trademarks are throughout Pokemon Go. Likely okay. I would have gone into more detail about that. So there's a call to action to brands, right? So there's opportunities here for marketing and advertising within the virtual world. There are licensing opportunities. There's the opportunity not just to register, like if you're a a platform. You can register the name of your virtual reality product. You can register the content created inside. But there's also movement and sound trademarks you could potentially register that are unique to the virtual world. But policing is going to be a much increased burden, and it's something that brand owners are really going to have to start to think about that really haven't thought about before. So I will stop there. Sorry, I went over. There's me, if you have questions.
Thanks very much. So now we're going to shift gears a bit and talk about patent issues for the rest of our time on this panel. Our first speaker is yet another of our Maryland alums. Her name's Elizabeth Gemmel. She's a former patent examiner, and now she works as a patent attorney for the Marbury Law Group, where she does a lot of patent prosecution work, all relating to different kinds of virtual reality and display technologies. Elizabeth?
Thank you. And thank you for having me and for Ashley to organizing this great event. I'm the first of the patent contingent, so I'm going to give you a little bit of overview of what a patent is and all that stuff. And I'm going to thank you for enduring and indulging my analogies, because patent world with Nathan and Julie, when you're talking about the intellectual property of trademarks and copyrights, it's pretty intuitive. We all interact with that on a pretty regular basis. Patent law is not intuitive at all, and it can get a lot in the weeds. So I've sort of come up with a couple analogies and to break it down to make it simpler to understand, just briefly. So what is a patent? Let's start with what it's not. It's not the golden ticket to Willy Wonka world to show up and have your invention just made. I really would love to make a Wonka world for all my inventors. But what it is it allows the holder to prevent others from making and using or selling a product. So I always kind of relate patent law to real estate law. When I'm trying to get a patent, what I'm trying to do is I'm trying to negotiate the boundary lines of my intellectual property. So during the patent prosecution process, I'm negotiating with the examiner of where I can put my fence posts. I want to put it here. Okay, you're fine there. I want to put this one here. No, you need to go 2 steps to the left and back 3. After you get through the whole patent process, you now have your fence posts and your boundary lines defined. But you just have a piece of land with a fence around it. You can prevent others from trespassing within the land, but you can't, there's nothing that grants you the ability to do something with the land. You have to actually take more steps to do that. So why does that matter with virtual reality? Let's get back to virtual reality, right? So in typical product cycles, patent activity, the going after the land of a particular technology tends to happen about 5 years before commercialization, 5 years before it comes into commerce and marketing and, so 5 years before it gets on a shelf to be bought, it's filed. Patent examiners don't typically pick up the patent until about 2 years after it's filed. It takes about 2 years to get a patent. These are all really rough estimates. That means you have a patent less than a year before a product goes to the consumers. What's different with virtual reality is that the early virtual reality patents are now expiring, which means that they have been filed 25 years past, and they have been going after the land grab of who wants what land for 25 years before a consumer has really, truly had a chance to play with it yet. So there's not a lot left. The stuff that's left, there's always more land because it's ever growing, but there are nuances and there's little bits of here and there. And the nice little change is Alice. Changed the rules. So now, all these patents that have been patented for 25 years, courts have said, well, even if you want to try and enforce those patents, we've changed the rules, and those claims might not be enforceable. So this is going to set up a really interesting thing that goes on of, so we have 25 years of a portfolio to go after to enforce against people who are trying to, bringing to market all of these devices. And we have all of these patents that are covering all of this land, but can we even enforce them? Are they even worth the paper that they're printed on? So what the rule change was is sometimes you can have the ability to change your lines. You can change where your fence posts are. So we have new rules, we can change the fence posts, but we can't really do that, right? It depends on if we can do that or not. The rules that have changed from technical solution, that now that we're looking towards a technical solution rather than an intended outcome. The way I like to explain that is it's the difference between playing Mario on a side screen versus playing Halo first-person role-playing. We've changed the point of view. We've written a lot of these patent applications from the view of what it's supposed to do, what we're observing it doing. And now the courts have said, but we don't want that. We want you to do it from first person. And so it's set up this situation where even if we can change the boundaries of the patents that are already out there, the disclosure isn't there. We don't have the information in the applications of the story that we've told in the patent to do that. So that is the very interesting part of what's going on, the very big 1,000-level view of what's going on in patents with virtual reality, and why we're sort of looking at all of this. So I'm going to turn it over to my colleagues to go into a little bit more detail on now you want to file a patent, or now you want to enforce a patent, or now you want to buy a patent portfolio. What are you looking for?
Thanks, Elizabeth. Our next speaker is Professor Andrew Michaels. Professor Michaels is a visiting professor this year at the George Washington University School of Law in D.C. He teaches advanced topics in patent litigation. Professor Michaels graduated from New York University School of Law, and I understand that he clerked for the Honorable Judge Pauline Newman on the United States Court of Appeals for the Federal Circuit. So let's welcome Professor Michaels.
Okay, thank you. Thank you, Ashley, for inviting me and for organizing this. Please forgive me if my thoughts are a little bit scattered. It's, I just woke up and I haven't had enough coffee yet. So I actually am not really a big fan of technology. That's why I don't have any slides. And incidentally, that's also why I decided to go into patent law. But when Nathan was talking, I was thinking about one interesting question I was thinking about is if we actually do, live in this world where everything is done in virtual reality, what if someone invents something in virtual reality? Then do they get a patent? Do they get a virtual patent? Is there like a virtual patent office that grants the patents? I don't know, but that might be an interesting thing for someone to think about. Another thing to think about is if we actually are, if our technology actually is moving us in this direction where someone might actually in the future be wearing seriously a shirt that says, I went outside once, we might want to think about, is that actually a world that we want to live in? And actually, do we want to be incentivizing technology anymore? Something to think about. And that's a different question from, is the patent system actually incentivizing technology or not, which is also an interesting question. I happen to think that the patent system might not actually be incentivizing technology. It might actually be slowing down technology, but I also happen to think that that might be a good thing because I don't want to live in a world where I wear a shirt that says I went outside once. So those are some things to think about if you're into that sort of thing, but you're probably not. So I'm going to talk now about 35 U.S.C. Section 101 of the Patent Act, and to what extent improvements to virtual reality technology are patentable under 101. So until maybe 5 years ago, 101 was not really that big of a deal, but the Supreme Court has reinvigorated 101 with cases like Alice, saying that if patents are directed to an abstract idea, now you can't get a patent. And so there's also Section 102 and 103, which say that the patent has to be new and non-obvious. And so some judges, maybe before these Supreme Court cases, would say that really you shouldn't do the 101 analysis until after you've done the 102 and 103 analysis. And that is after you've already determined that that there's a new non-obvious invention, then you consider, is this nevertheless something that shouldn't be patentable subject matter under 101. And so then it would be a pretty rare case that something was invalid under Section 101. But what the Supreme Court has done in these recent cases is actually kind of move the novelty and non-obviousness analysis into 101. And so 101 is now being used in litigation as kind of a 12b6, motion to dismiss type of thing, where you, in a lot of cases now, there's a 12b6 motion to dismiss motion on 101, saying this patent should be invalid at the pleading stage under 101. And so the Supreme Court has said that one of the things you think about in 101 is, okay, is it directed to an abstract idea? And if it is the other stuff in the claim just routine and conventional? So for example, you can't just invent an abstract idea and say, put it on a general purpose computer. That would be invalid under 101 because the general purpose computer is routine and conventional. So what the Federal Circuit has said in some recent cases, though, is that this question really of whether something is routine and conventional is a question of fact, really. It's a question, it's like a novelty, non-obvious type question where generally you would have experts and introduce factual evidence on those questions. And so the Federal Circuit has said in a couple of recent cases that you can't take these if the pleader has adequately pled plausibly that the non-abstract aspects of the claim are not routine and not conventional, then you have to accept that as true at the pleading stage because it's a factual question. So that may be lessening a little bit some of the 101 motions to dismiss. But then with respect to virtual reality, one question then is to what extent is inventing an abstract idea and saying do it in virtual reality, to what extent is that patentable? In other words, to what extent is virtual reality technology already routine and conventional? It seems probably not yet, but maybe at some point it will be. But if you actually do want to get a patent on something in virtual reality, it does help to be as specific as possible as far as maybe a specific configuration of the sensors or something like that, so that you're not preempting too much. And also improvements to the virtual reality technology itself, as opposed to inventing an idea and saying do it in virtual reality. Improvements to the virtual reality technology itself are probably more clearly patentable. With that, I'll turn it over to my colleague, and he will talk more, I think, about that sort of thing. Thank you.
Thanks, Professor Michaels. Our last panelist today is yet another of our Maryland alums. His name is Zhang. Ngai is a counsel at Pillsbury, Winthrop, Pittman, and he works on a broad range of intellectual property-related issues that are of interest to startup companies. So he does some patent prosecution and post-grant review work, but he also works on things like IP due diligence, licensing, and a variety of other issues. Ngai?
Hi, so I'm gonna try to keep this down to like 5 or 6 minutes so you guys can ask questions. But there's been plenty of presentations about Pokemon Go, so I was just wondering, like, from the audience, has anybody ever played it? Just a few? Okay, a little disappointing. But so unlike Professor Michaels, I actually love technology. When the game first came out, like I played it for months. I was in Europe playing it. I caught Pokemon that were only existent in Europe, things like that. So that's actually the reason why, like, I got invited here today, was because Ashley, when I met her, she found out that, I love Pokemon Go, so she thought, this guy might actually know something about augmented reality and the law, right? I don't really know too much about that per se, but I will say, I was actually going to go ahead and try to use that as an example, but if you guys haven't really played it, but how about the Uber app? You guys have the Uber app? Okay, right, hands if you have the. Okay, great. All right, so you can take out your mobile phone. Does anybody have their phone with them? All right, take it out. Open up the Uber, Lyft app, whichever one is your preference, right? And so the first screen that pops up is what? Anyone want to tell me? A map, right? And what does it let you do? It lets you move stuff around. Tells you, like, you can indicate, like, what your location is. Okay, so can you, if you move the thing around, like, what happens? The pin moves around, or does the map move around? The map moves around, okay. So now, is that something that's patent eligible? I mean, does anybody know? Does anybody know anything about Alice? Is that something, do you think that that's something patentable, or do you think that's like people have done this before for many years? It's not patent eligible. Hands raised if you think it's patentable? Patent eligible? Nobody? A couple? All right, so hands raised if you don't think that it's patent eligible, right? And so, I would absolutely disagree with most of you, obviously. I do think that there are arguments for why that would be patent eligible, and I think that's, I think that, the patent office, not the patent office, maybe like many examiners, that there's quite a bit of confusion, and so, part of it stems from the fact that Alice came out back in 2014, and there's really still no, like, objective standard for what falls into this patent eligibility zone. And so in the past, the question was, everybody knew you couldn't patent something that was directed to an abstract idea. So what they used to do in a case called Bilski was that, if you had something that they alleged was an abstract idea, then what you do instead, you say, well, now I'm going to go ahead and perform it by a computer. And now it's tied to a machine, so there's absolutely no way that it's abstract. Well, Alice came out, and Mayo came out, and was like, look, it doesn't matter. You can't just say that a machine does it. It doesn't make it, or it doesn't take it out of the zone of patent ineligibility, right? It's still directed to an abstract idea. So now the question is, what is an abstract idea? And I really don't know. I can't tell you, right? What they have done, though, is that the Patent Office has, like, provided these examples of what's patent eligible, what's not patent eligible, what's directed to an abstract idea, and what might not be. And so Let's see if I can go ahead and try to do this in a couple of minutes. So, I have this map example. The two-part test that they take a look at is that they first ask whether something is directed to an abstract idea. And so let's see, how do you play this? Review. I love technology. I'm just not very good at it. So I'm just gonna do this. It's fine. It's no big deal. Cool. Awesome. Right. So there's this two-part test. First question is it directed to an abstract idea? For the software purposes, that's really all you have to ask, right? But then again, I don't really know what an abstract idea is, so I can't help you with that. And then the second one is, does the claim recite additional elements that, as a whole, make it significantly more, right? I also don't know what significantly more means, so, we can't really help you there. Like, as I mentioned before, nothing in Alice really kind of gives you any kind of guidance. The Patent Office has tried. And so this is one example, right? Exact same claims. The only difference is this blue area where they say, look, if you're scaling this textual information, there's like additional detail on the left side, and there's not as much detail on the right side, right? Well, the one with a lot of detail, and it has all the elements of the other one, well, the Patent Office in that example says, look, that's an abstract idea, right? Because this blue part, it's kind of like a mathematical algorithm, right? And that's kind of abstract. It's not really tied to any kind of physical, tangible thing. So that's definitely abstract. But you know what? If you don't tell me like this other information, if you actually give less detail, it's not abstract, right? So that's actually pretty confusing. And so the reason is because when they're trying to like distinguish the two steps that the Alice court came out with. So if it recites any kind of what they think is an abstract idea, suddenly it's an abstract idea. And then they go to the second step and they say, well, look, this improves the user's interface as a whole, right? And therefore it has significantly more. And thus, both of these are patent eligible, right? So they say, right? And examples they give is like improvements to the functioning of the computer itself, improvement to technology, et cetera, et cetera. So the problem is like all these cases start coming out. There's actually only like maybe half a dozen or so Federal Circuit cases that actually found something to be patent eligible, the precedent ones anyways. And so it kind of now meshes because instead of saying, oh, does it recite an abstract idea, all of these cases are finding that under the first step, right, is it directed to an abstract idea? You actually have to look at the claim as a whole. And so if it improves a functioning of a computer, if it improves another technology, if it improves the user interface, under the first step, right, it's not directed to an abstract idea, so they say. But under the guidance from the Patent Office, it's something different, right? This is supposed to be something that was supposed to be in the second step, the significantly more step. So obviously there's tons and tons of confusion here. And so you would think that, all right, fine, patent examiners, they mess up, no worries, you appeal it. The appeal board will figure it out. But like, analysis of like 500 samples done. Basically, they're kind of rubber stamping everything that the Patent Office is doing. And so Professor Michaels mentioned this case that came out that said, oh yeah, now it's actually a question of fact, right? And so let me see. It's a question of fact, one more minute. And I'll just point at this example that they gave. They said that DDR is one of the cases that they found where it talks about retaining a website visitor, and it talks about all these facts about retaining the host's look and feel, and it merges his content, right? So this is actually my first loss, right? This came out, I lost this case supposedly, and they said, look, you look at Ngai Zhang's claims, or the claims that he has there, and it has nothing to do with like websites, has nothing to do with look and feel. It's not exactly the same as, the DDR claims, and therefore you can't use it, right? And so that's kind of weird because, there's only 6 cases that come out, and if my claims are exactly the same as the Federal Circuit's claim, right, then I didn't invent anything new. So, it's hard to win those kind of things because it's like they look at your claims and they're like, oh, well, DDR, McGrow, all these Federal Circuit cases, that's technology, Yours, it's not technology, and so, yada, right? It's not patent eligible. These are the other things that they've said. They said, look, yours uses computers, therefore, and you said in your specification that it uses computers, and thus, given this context, we don't think that your claims are patentable, right? And so the question is, doesn't everything use some kind of sort of generic sensors or things like that? And the other thing they say, look, if you take out the computer components, right, you can do it by pen and paper. So the question is it a test or is it just supposed to be some kind of helpful guidance or a helpful tool? And so this is one of the claims that was found by the Federal Circuit to be, patent eligible. But if you take a look, right, it doesn't even recite anything about computers. And if you take a look at the basic rules itself and the basic limitations, it seems like a human can do it. So another example is this one, right? You just determine orientation. If you do some mathematical stuff, and a human can actually perform this mathematical function. But nonetheless, the Thales Federal Circuit Court decision found that it was patent eligible. And so, that's why all of this is like really confusing. I think everybody else, or the patent office, is having such a hard time with it. And so here's like the VR, AR invention stuff, right? If you want to show an improvement to like a VR, AR user interface, right? Something very, very simple. And by the way, I actually drew this, so I have the copyright to this image, so just FYI. The issue here is, look, when you're in virtual reality, you get sick, right? Because you have like no point of reference. So, I think there are patents out there on this. I'm not really sure, so, obviously at this point it's not new and novel, but the question is whether it's patent eligible, right? The problem is, in the context of virtual reality, you get sick. So the solution is, look, I'm gonna put a nose in there, right? Isn't this arguably an improvement to that user interface? It improves the user experience, right? And so this CTO at Oculus VR, he's throwing out this other example. So are you improving virtual reality, augmented reality technology? If you make it, if you make it so that it uses less resources, if you make it so that it runs faster, I argue if yes, if it's new and novel, then probably, right? And so last thing that I have is, like, you guys were talking about this whole user interface. The reason why I think it's patent eligible, or at least arguably, is because if you remember like the old days, maps.com and stuff, you actually have to grab that pen and move it from somewhere else, right? Right now they have this basically two layers, right? They have the map layer and they have the pin layer. And now because you're using a mobile interface, it's harder to use that pin. So the argument is now you just move the map layer underneath, right? And the pin moves. So does it improve the user interface, right? Thanks. Sorry, I went 8 minutes.
Thanks very much. So we probably have time for just a quick question. If anyone has anything they want to ask the panel. Yes.
So I don't know if you guys have actually been following the Google v. Womble patent dispute over basically the Java code, and I'm wondering if you foresee a rush to get control of the code or get patents over the code that's used in VR and AR as the underpinnings of all these systems. Because basically, if you can control the coding language, you can basically sue anyone and everyone who's creating an app using that code.
It's probably more of a question on copyright.
Yeah.
If you want to do it.
Right. So computer code is, whether this is a good idea or not is a different question, but computer code is copyrightable as a literary work. And so computer code is, upon creation and fixation, which meaning as soon as you've written down your line of computer code, you have copyright in it, and that's going to last for the life of the author plus 70 years. Or for corporately authored works for 95 years. So copyright is definitely the way to go if you want to own it forever. And so what copyright in computer code doesn't do, however, is permit you to prevent alternative versions of accomplishing the same thing. And so that's where patent would theoretically at least come in to take the place of that monopoly. So you can write the code, but then someone else writes different code that does the same thing, and there's no copyright implication there, but there could be a patent implication there. And so if your objective is to lock down the market, you actually your better bet is going to be patent, simply because you can't prevent other people from writing alternative versions of what accomplishes the same thing.
And the challenge with that is what's been going on with Alice is because everyone is having a hard idea understanding what is patentable or not, the whole point behind patents is to make it public. And so if you can't get a patent for it, there's no reason to make it public. And because there's been so much uncertainty behind Alice, what a lot of people have been suggesting, including the former US patent commissioner to his clients, is to keep code like that trade secret, which then you can actually enforce and prevent anyone from doing it because it's not actually out in the public, and the only way that you can enforce it is then through employment laws. So it's a really interesting dog chasing, tail chasing. How do we make a decision on how to do this, and we're still trying to figure it out because, like Ngai said, we still don't have clear guidance on how to get over the Alice issue, to patent things like that. For me, the way that I typically go to try and get as close as possible is to write it from the first point of view. Honey, I shrunk the patent attorney. I shrink myself down and put myself like I'm standing on the processor in the machine, and I watch the signals come in and I watch the signals go out. I figure out what decisions I'm making with all of that information. And then that's how I write the patent applications. And that for me is about the extent of how we figured out how to cover that in a patent process while still playing by the rules and not doing the copyright because it has to be exact. The code has to be exact. If one line is off, they don't infringe, or whatever is it in copyright.
But also thinking back about what the objective of grant of a copyright or patent is for, it's to incentivize creation, right? And so we currently are granting these monopolies in order to allow there to be monetary incentives to create. However, if the system is being used to prevent other people from creating and to prevent competitors from entering the market and to prevent there from being a variety of options and a variety of choices for consumers, it's arguable that we're not actually achieving the objective, which is the improvement of user experiences across of all of these products, whether those be expressive creative works for copyright or inventions and ideas and products for patent. So maybe it's not such a bad thing that it's hard to find ways to identify things that are not abstract for patent, and maybe it's not a bad thing that copyright doesn't actually protect ideas. Maybe that's good for us.
So we have time for one more question if someone has something they want to raise. Yes?
My question is for Ms. Gemmel. Do you have any predictions about who's going to win this, or who might win this race to the patent office, the new guard coming in now or the old guard who had the patents 25 years ago? And are there any clues in any of the existing kind of filings under the old rules that might help you make those predictions? Or is it totally a Brave New World free-for-all now?
Yes. Yes. I think we don't know who all the players are yet. I think that's the biggest part, because for 25 years, there are so many players, and it could be that it is one person who was in his basement doing something that got one patent that is going to be the keystone of all of this. But we don't know who that is yet because we're not selling enough units yet, because a patent prevents people from selling and making and using. I think we can't change the claims that are there now for most of them. the re-exam process and the ability to change it is not good for most of the work that's out there of the underlying foundation of virtual reality stuff. But I also think that you have the ability to look at claims of patents that are out there to see, is it really black? Is it really white? Or, okay, can we make there a really valid argument of, okay, let's, even though it was written before we knew what the rules were going to be, was it written in a way that we could still argue that it's not an abstract idea? Because really that's the big thing, is that they're getting to courts and the courts are just saying, abstract idea, abstract idea. Because we don't know, because the Supreme Court has flat out said we're not going to define what an abstract idea is. We're just going to give you examples. So it turns into this, I've got a spidey sense, I know it when I see it, but I can't tell you why. So it's very subjective. And it's very unknown. So, but we're getting more and more clarification. The Patent Office in January finally, after all these years, have finally included 101 and the evaluations in the MPEP, which is the Bible of patent law, which includes comments and it includes examples and how they can think through it. So that gives us an idea of how the courts are going to do it. So.
Okay, well, would you please join me in thanking all of our panelists for this great discussion? And at this point, we're going to move over to the Krone Guard room, and our keynote will be starting in a few minutes. I think you went about 20 minutes.
I'm sorry.